Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. In the last few videos, we talked about how critical it is to keep paying the renewal fee to the patent office for keeping our patent alive and keeping our rights enforceable. There is another obligation that has been imposed by the patent office on the patentee and the licensee with regards to the patented invention. They are required to provide a statement, a detailed statement of working of the invention locally. Now, you may ask, what is the requirement of that? What is the logic of that? Let's try to find a logic behind such a request by revisiting the entire premise of the patent system. A patent is granted to encourage innovation, to enable transfer of technology to the society, which would lead to further technical advancement. Now, it is perceived that such an objective can be achieved only when the invention is worked locally, that too at a commercial level to the fullest extent possible. If that's the case, how does the patent office track whether the patentees or the licensees are even complying with such requirement? In a sense that the inventions are actually getting worked in India. Now, in order for the patent office to keep a track of such a compliance, Patent Act has put the onus and obligation on the patentee itself for them to provide the statement, a detailed statement regarding the working of invention. Section 146 is dedicated to defining the procedures, timelines, and the requirement around it. Let's visit Section 146. As per Section 146, a controller can send a written notice to each patentee, each licensee associated with a particular patent and request them to provide a statement regarding working of the invention in India. Section 146.1. Upon receiving such a request from the controller, each patentee, each licensee, all sorts of exclusive or otherwise, are required to revert to the controller within 2 months plus any additional time that they may avail. Now, what all information needs to be provided and in what format that need to be provided? So, as per Rule 131, Form 27 needs to be used for providing detailed statement regarding working of the invention. Now, there could be a case where invention has not been worked in India. In such cases, the statement should provide the reason for which the invention was not worked in India and what are the steps that have been taken to make the invention work in India, along with any timeline that they can be provided. In case the invention is indeed worked in India, then the extent to which the invention is worked in India needs to be provided. Now, how do you quantify the extent to which the invention is worked in India? Now, one such parameter is the revenue or value that can be attributed to the patented invention by maybe manufacturing in India or by importing the patented invention to India. Such details on Form 27 needs to be provided to the controller. Upon receiving the information from the controller, such information gets published. This is one case where controller is proactively seeking details from the patentee. Now, irrespective of whether controller is seeking the information or not, each patentee, each licensee is under obligation to provide statements with regard to working of invention in India every year as per Section 146.2. So, a statement pertaining to the working of invention in India should be submitted for every financial year. Now, when do you submit it? Within 6 months from the expiry of the financial year. Now, in India, we have April to March as a financial year. So, 6 months from March, which is September. So, every year by September, such an information should be furnished to the patent office. We already discussed what all information needs to go under Form 27. Such information obtained from the patentees gets published. Now, what if the patentees fail to provide the information or maybe falsify the information that they have provided? To handle such non-compliance from the patentee side, there are provisions in the Act for imposing punishment. Section 122 talks about the punishments in case of non-compliance of requirement under 146, statement for working of invention in India. If the patentee refuses or fail to provide details as requested by the controller, a fine up to 1 million Indian rupees can be imposed on the patentee. What if the information was provided but was a false information, fabricated information? In such case, there is a provision for imprisonment up to 6 months plus the fine that we spoke of. With this punishment provisions in place, Patent Office is hopeful that everybody is going to comply with the requirement. One interesting question for you to answer. Can a patent be revoked for a reason only that Form 27 is not filed regularly, or the information content in Form 27 is fabricated? It's for you to answer. So apart from the requirement of paying renewal fee every year, we have another obligation to provide such working details to the patent office year after year using Form 27. An interesting development with respect to Form 27 is that the requirements of Form 27 has been simplified to a great extent in 2022 as compared to what was there earlier. Earlier, a patentee was required to provide details individually for every patent. Now, a product may have multiple patents around it, so identifying or attributing value corresponding to this particular patent on the product is very difficult. Therefore, it has been simplified by saying that you can file one Form 27 for all the patents together. Another requirement that was there earlier was to provide the details of licenses. Now, people were not happy about it, citing confidential reasons. Another requirement was to answer if the public requirements were met adequately, partially, or fully. And there were no guideline to quantify what is adequate, what is partly, or what is completely. So the requirement of that information also is removed from the Form 27. So at this stage, if an invention is actually getting worked in India, owned by a patent or by multiple patents, it's actually fairly easy to provide details on Form 27. So complying to such details should not be great concern. This brings us to the end of this session. In the next episode, we will discuss various details about secrecy provisions, the procedures and the timeline associated with it. So I'll see you in the next video. Till then, be well and take care.